Director with the Federalist Society. Today, I'm very excited to introduce Judge John Bush of the United States Court of Appeals for the Sixth Circuit. Judge Bush grew up in Arkansas and then attended Vanderbilt University, where he graduated summa cum laude and was inducted into Phi Beta Kappa. After attending Vanderbilt, Judge Bush then matriculated to Harvard Law School, where he graduated cum laude, and was an editor on the Harvard Journal of Law and Public Policy. He was also a Moot Court finalist. Afterwards, Judge Bush then clerked on the United States Court of Appeals for the Eighth Circuit, and then went to Gibson Dunn in Washington, D.C., where he focused on litigation. Judge Bush then made his way over to Louisville, Kentucky, where he continued in private practice and was president of the Louisville FedSoc chapter. In 2017, President Trump nominated Judge Bush to sit on the United States Court of Appeals for the Sixth Circuit, and he was confirmed by the Senate the same year. He sat on that court for 7 years now, and we're very excited to have him back by popular demand back at the University of Chicago Law School. So with that, please join me in welcoming Judge John Bush.
Why is everyone on this side of the room? I'm trying to figure out. I'm gonna try to not ignore everyone over here, but I'll be looking, I guess, mainly over here today. But it's great to be back. As Matthew indicated, I've been here before. I think this is the fourth time I've spoken here. So fortunately, there's turnover in law schools, so I can reuse some material, although I'll have some new things today to say. The first half of today, you may have heard before, is relating to the history, tradition side of the title. The second half, we'll talk about AI, which will maybe be the reason people are here to hear something new. But I was wondering, of those that are here today, how many 1Ls do we have? Wonderful, wonderful. How many 2Ls? Okay, and 3Ls. Okay, well, it's a good sprinkling of all the classes. I'm going to be talking about an interdisciplinary topic, and I'm afraid to say when I went to law school, I was trying to get away from science. I think my worst class in undergrad was computer science, so I really have a lot of qualifications to talk about AI today. But I thought going to law school you'd get away from science. Of course, this is the place where you all thrive on the hardest, social science at least. So maybe I have some folks here who don't have a problem with mixing law and science. Also, there are critics who are saying it's not appropriate to mix law and history. I call people like me, who are originalists, the worst names in the world. You know what they call us? Amateur historians. So I'm here to at least maybe give some background as to why I think the history and tradition method might be a good way to look at interpreting the Constitution. And I'm also going to talk about how the development of AI may have big implications for the history and tradition method that the Supreme Court has recently used to interpret certain provisions of the Constitution. So let's begin by talking about what's happened at the Supreme Court in the last few years. I think it's fair to say a majority of the justices now subscribe to the view that that historical context and examples and accepted traditional practices can inform the meaning of constitutional text. Now, there's been some quibbling as to whether or not history and tradition is the same as originalism. I tend to think it is pretty much the same thing. It's a relabeling of the methodology, but I'm not here to really debate that today. I'm going to assume history and tradition is essentially the same thing as originalism. As you know, the history and tradition method made the headlines a couple of terms ago with three big cases. First, the Dobbs case, which dealt with the right to there being no federal constitutional right to abortion. Second, the Bruen case, which addressed the Second Amendment issue, and then the Kennedy case, which was a establishment clause, or I guess it's more of a free exercise case involving the right of the the coach to pray at the football field. But in each of these cases, it's interesting, the court was relying on history and tradition, and to a large part for its reasoning. And that wasn't the end of it. By my count, the court has relied on history and tradition as a primary driver for its reasoning in at least 8 cases that have been decided in the last 2 terms of the court. Now, of course, last fall, we had an argument in a case that hasn't been decided yet, the Rahimi case, which was another Second Amendment case involving the prohibition of gun ownership as part of a domestic violence protective order. In January, we had the Loper Bright Enterprises case, which you might think is an administrative law case, but I would say it's a separation of powers case. And that, of course, will address whether or not the Chevron doctrine survives. And I suspect history and tradition will have something to say about that as well. And then, of course, the recent Trump decision involving interpretation of Section 3 of the 14th Amendment in the context of whether President Trump could be removed from a ballot. I thought it was really interesting. I was listening to the oral argument in that case, and Justice Sotomayor said this during an oral argument. She said, quote, "History proves a lot to me and to my colleagues generally." So if you've got Justice Sotomayor saying that, then it seems like to me history and tradition is it's ruling the day now amongst all the justices to a certain extent. Now, I'm just a listener to these audio recordings just like you are, but I have to try to figure out how the rulings of the Supreme Court apply in my court. I'm on the Sixth Circuit, which of course is the states of Kentucky, Tennessee, Ohio, and Michigan. And we're trying to figure out how we're going to apply these decisions. But I've been struck by some of the things that other judges have said, lower court judges, about the history and tradition method. And in particular, I was struck by what Judge Carlton Reeves of the Southern District of Mississippi wrote in an order a couple of years ago. And the issue before him was whether it was constitutional for a federal statute to prohibit felons from possessing firearms. And to answer that question, he had to apply Bruin. And in the course of that case, he wrote, the opinion he wrote, "This court is not a trained historian. The justices of the Supreme Court, distinguished as they may be, are not trained historians. We lack the methodological and substantive knowledge that historians possess, and we are not experts in what white, wealthy, and male property owners thought about firearms regulation in 1791. Yet we are now expected to play historian in the name of constitutional adjudication." Well, there's a lot to unpack there from what Judge Reeves had to say, but he does not appear to be a big fan of the history and tradition approach. His critique reminds me of what I hear at law schools when I talk about history and tradition, and the question basically is, isn't this all smoke and mirrors? It really isn't the Supreme Court just using history and tradition to cover up what's really going on, which is that it's policy decision making at the court. Well, I guess I'm not here to defend everything about history and tradition today, but I do want to point out a few things about the method before getting to AI, which will, believe me, it all ties together in the end. I would say that the history and tradition method, the virtue of the method is that it gives us at least some basis to decide cases in a way that I think can be defended as an objective manner of decision making. I would submit the only conceivable alternative to history and tradition is to have some sort of a judicial philosophy that is guiding the judge in making decisions. But if you go into judicial philosophy, who are you going to follow? Should it be John Rawls, Ronald Dworkin, Adrian Vermeule? At least with history and tradition, you have a means of judging the merits of the court's decision making. So you have a lot of criticism of the way the court applies history and tradition, but the critics at least have a base by which they can point to say, you missed this in the history or this in the tradition, and that's a way to critique the reasoning. Now, for an originalist like me, the point is not simply to discover what happened in the past. It's for a specific reason, to determine based on history what would the average person have understood the words of a legal text to mean when that text became law. So for statutes, it's when the statute was enacted. But when we interpret the Constitution, the task is to determine the ordinary meaning of the words when they were ratified. So that job is not, as Judge Reeves seems to imply, to intuit what particular founders who adopted the text were thinking with all of their biases and prejudice. Rather, it's to figure out what the meaning would have been as held by ordinary people in the ratification generation. Now, throw that out and you think, well, you didn't have focus groups in the ratification generation. How are you going to ever determine, what the ordinary meaning was of words at the time of the founding? Well, I'll respond to you with this. Why is it that in contracts, we're always talking about objective meaning of contracts? We don't do focus groups to determine objective meaning of contracts. But the difference is in contract law, you're looking at the words as they mean today. Because in a contract case, the people who put the contract together are still alive, for the most part. And they're in front of you arguing over what the meaning is. So you're going to think in terms of real-time meaning of words in contract law. Constitutional law, you're also looking at meaning of words under the originalist or history and tradition method. But the difference is you're going back in time. You're trying to recreate that era in terms of what the meaning is of the words. Now, it's more difficult, obviously, in historical research than it is to do it real time. But conceptually, I would submit there's not much difference between the way you look at contracts and the way you apply history and tradition method under the Constitution. Now, to determine meaning under the history and tradition method, we should look to the entire historical record as it exists. And that would include not only judicial opinions, but all written communications, be it letters, newspapers, pamphlets, treatises, whatever. One way of looking at this is that the case law is essentially a secondary source telling you what the meaning of a constitution is, whereas all the other documents are primary sources that you're looking at to determine meaning of the Constitution. So essentially, when you do history and tradition, you're going back and it's like a form of quality control review of the case law. By looking at what the full historical record says the meaning is, it's a way to QC whether the judges have gotten it right in the way they decide cases. And the answers to constitutional questions using this history and tradition method may surprise you. For example, under the 4th, 5th, and 6th Amendments, history and tradition can lead to more constitutional protection of individual rights than exists under judicial doctrines developed with non-originalist methodology. The fact that originalism can lead to both conservative and progressive outcomes in different contexts is a testament, I would say, to its objectivity. Now, granted, in the last couple of terms, there have been some notable cases decided using history and tradition that have been written by, quote, conservative justices. Thomas wrote Bruin, Alito wrote Dobbs, Gorsuch wrote Kennedy. But others were authored by justices who fall on the, quote, progressive side. Breyer wrote Torres, and in many cases, Kagan, Sotomayor, and Jackson each penned concurrences or dissents that relied, at least in part, on history and tradition for their arguments. They also joined Robertson's opinion for the court in Moore against Harper, which relied on history and tradition to interpret the Elections Clause. And Justice Jackson made what could be called an originalist argument based on history and tradition in her dissent in Students for Fair Admissions. Now compare this to the outcomes of various philosophers, which I would submit inevitably lead to the same political outcomes. Ronald Dworkin always seems to produce progressive outcomes, and I suspect Adrian Vermeule's approach is going to lead to conservative results. The history and tradition method by no means is a perfect methodology. There are many open questions regarding that approach. For example, which historical documents are relevant for determining meaning? What is the hierarchy of significance for those documents? That is, should some sources be given more weight than others? What time period should be considered? That is, how far back and how far forward do we go in terms of the text that's being looked at? How do we take into consideration the motives, biases, and prejudices of people whose communications are being studied? And of course, what's the appropriate level of generality and relative comparators for making analogies in this process? The answers to these questions and others should all factor into the analysis under the history and tradition method. And they have to be addressed to have a truly viable standard. But I suspect as answers to these questions are worked out by the courts, it'll be sort of like every other area of law. Eventually, you're going to have a restatement of methodology of the history and tradition method. And I wouldn't be surprised if an organization like the American Law Institute someday engages in that process. In these ways, case law can be developed that's consistent under the history and tradition method. So now we get to the part that maybe you're here for. What is the future of history and tradition in the Supreme Court? Well, if you look at the way it's been used in the court, it's been applied in a lot of different areas. The Establishment Clause, Free Exercise Clause, the Second Amendment, the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, the Due Process Clause of the 14th Amendment. In all these cases, the court has abandoned the use of balancing tests. For instance, the court recently confirmed that it no longer uses the Lemon balancing test for Establishment Clause cases. Anyone know what the Lemon test is? It's not taught in law school anymore. Okay, a few people know. But like that was what I was taught, was the Establishment Clause analysis in law school. It was the Lemon test. You remember some of these cases like the Erie Doctrine, you think about Halloween or whatever. But the Lemon test, you don't hear about it anymore. But that's an example of a once was considered black letter balancing test law that's no longer followed by the Supreme Court. So I suspect the court's probably going to be moving away from balancing tests in a lot of different areas under the Constitution. Because balancing tests were not with us at the founding. They are a 20th century creation. In the 18th and 19th centuries, courts interpreted the Constitution in a manner akin to the history and tradition method. That is, they determined the constitutionality of a law based simply on whether it was outside the bounds of permissible government authority under the original understanding of the Constitution. There was no need to balance. The problem with balancing tests is that they require us judges to make things that look like policy. We have to decide whether a government interest is sufficiently important, compelling, or narrowly tailored. Where do I get the expertise to be able to tell an elected representative whether they have a good enough reason to pass a law? It's just odd. So history and tradition moves you away from that policy-driven analysis to an analogy-driven analysis. So we'll be talking about that more as we go along. We know from recent years that when the court hears cases with little judicial precedent, it's more than willing to dive into history and tradition. In Heller, of course, there was relatively little Second Amendment case law. So they felt free, both the majority and the dissent dove in and applied history and tradition. And also, of course, in the Trump ballot access case that we just had come down, there wasn't any Supreme Court precedent on that that was relevant in that case. So the court's decision was replete with references to history and tradition. But I think that this is going to be used, history and tradition, even in areas where there's been a lot of case law. And that, of course, is what happened in the Dobbs case. So I predict future use of history and tradition at the Supreme Court. But what about the long term? Doesn't that just simply depend on who the justices are on the Supreme Court? That's kind of the easy answer to that question. But I would submit the viability of the history and tradition method actually will turn on the development of new technology. Why do I say that? The history and tradition method relies on linguistics history. That is, a historical record of how words in the constitutional text were used at the time of adoption. It also encompasses context and pragmatics of words. The inquiry uses dictionaries and other primary sources from the time of the law at issue that use those same words and phrases. By examining those other uses, we discern how the words were used in the legal text. Now, technology comes into play at this point. I'll mention corpus linguistics. Now, fortunately, I think Justice Thomas was here last week to give you a primer on corpus linguistics, so I won't have to go through all that with you. But what's interesting about what's happened at BYU Law School is that they took a process, using a database of material that could be searched for word meaning, and they took it from the linguistics field and they applied it in the legal field. And essentially, you're putting in as many documents as you can from a particular historical era, and when you do the search, you can get hits back telling you how those words were used and their word meaning in that particular era. Now, I suspect that there are some who are suspicious that corpus linguistics in the legal field has a conservative agenda, because many people interested in the area have tended to be right-leaning. But corpus linguistics as a general field has not had any particular political bent. That's because Silicon Valley is using corpus linguistics in all AI that is being developed. Now, they may not call it corpus linguistics, but that's essentially, I think, what's going on. At BYU, it's still a process that involves you, as the user, manually doing a search term and then getting results, and you have to manually, as the user, go through and determine what the meanings were and the different documents that come up. It's highly laborious and time-consuming. But what if AI were employed to do all the review of the hits and compile statistics on word meaning and usage? If the AI could be trusted, that would make the job of determining word meaning and usage much easier. And it seems as if that's what companies are doing with AI in other fields. In the last few years, AI has developed, as one reporter put it, quote, to consider the relationship between words, even if they are far apart in a text, and to determine which words and phrases in a passage are most important to pay attention to. And with the development of new technologies, AI now, quote, can be trained on larger data sets and built with more parameters. So what does this mean for the law? I predict that more robust corpus linguistics will ultimately be offered by companies such as probably the usual suspects, Westlaw, Lexis, but we may have others enter the field. AI would allow us to easily quantify meaning of words and word usage. By quantifying, it means determine how often a term or phrase is used to mean a particular thing versus something else. Rather than pull out of a hat whether or not a word is ambiguous or how vague it is, we will actually have statistical methods to get some answers. And if the database is comprehensive enough for a designated period in history, AI should allow judges to fully recreate, at least to the extent it is documented, how the generation that ratified a particular constitutional provision used words of that provision. Now, one criticism of this approach is that it doesn't capture verbal speech. Now, for a modern corpus, that's no problem. You can dump in there text, social media, even voicemails that have been, obviously you can get the text of a voicemail. So that's no problem in the modern era to be able to build a corpus that's going to capture all speech, which will allow us to be able to use it for statutory interpretation. But what about the founding era? How do you deal with the fact that you have people, a lot of people that were illiterate? Obviously you have enslaved people that were not going to be producing documents. That's going to be more difficult. But I think perhaps AI could overcome much of that problem by picking up clues in documents as to verbal speech. For instance, there could be more downloading of common letters and other documents that have not made their way into printed material but could be ultimately transcribed and put into that database. And AI could pull that information to come up with information about verbal speech as well. I'll give you an example. This may sound totally far-fetched, but I was reading this last month about some students who won a $700,000 prize for using AI to decipher an ancient Roman text that had thought to be unreadable because the scroll had been burnt during the Mount Vesuvius eruption in 79 AD. These students were not high-tech people. They were in the philosophy department. But what they did was, so I mean, if they can do it, we can do it, okay? No, they used high-tech CT scans to unroll the scroll. So this scroll was like a big chunk of, like a piece of concrete almost. And so you couldn't, if you unroll the scroll, it's going to destroy everything. So they used CT scans to unroll the scroll, virtually. At that point, the black carbon ink used on the scripts was indecipherable from the papyrus. But what the students then did is used an AI model that was able to work out the lettering using pattern recognition of this ink on this scroll. And they actually were able to figure out what the scroll said. So I'm just saying, if they can do that, I mean, I think your imagination is just there's no limit to the imagination of what possibly could be done using technology to uncover the past and learn more about history. So I throw that out there for you to think about. I also think AI can be used to more easily research historical examples. It'll allow you to find these analogies that might be relevant for comparing whether something today has an analog or how close the analog is from the time when the constitutional text was ratified. But we're obviously not there yet. Now, ChatGPT, as you all know, has had some problems. There was this article recently that said that legal analysis, although good, was not great, certainly not on par with the top appellate court judges. So I considered that to be a good sign. But the fact that AI is being considered for legal research and writing reflects assumptions that I submit align with history and tradition approach. The use of AI to find the correct answer to interpretive legal questions assumes that there is a meaning of text that is objective, not subjectively driven, and that it can be discerned from evidence of the past. And that, in my mind, is what the history and tradition method is all about. So will the final result be that the machines are going to replace us judges in deciding constitutional issues? No, for at least one good reason. The Constitution itself vests judicial power in people, not technology. As you know, Article 3 creates the Supreme Court and the lower courts to have judicial power. Courts are made up of people, and that necessarily implies that ultimately the interpretation of the law is for humans to do. But perhaps judges may rely on AI for assistance, a form of expert opinion, if you will. For instance, one could argue that it would be permissible for a judge to use AI analysis of statistical probability that a word or phrase had a particular sense or meaning in a particular historical period. Of course, there are issues of transparency and reliability that would need to be worked out. Imagine a Daubert-like test to determine whether the results of AI may aid with legal interpretation. And as you know, there's that problem of hallucination. Developers have to fix that phenomenon of AI making things up to get the answer. Before relying on anything generated by AI, it would be the judge's role to determine that it's sufficiently reliable and weigh the significance of whatever it generates as evidence of textual meaning. So I'll wrap things up today with a few final observations. Much of what I've said today may not come true, but I do sense that we are entering a new era of human history, a new Enlightenment period, if you will. We are focused on machines to find answers. Answers to humanity will be found through computational methods. And for the first time, we can rigorously address linguistics questions that are at the heart of textual analysis. The AI methods are futuristic, but they're rooted in the past because they involve review of earlier created data. And there are certainly problems with history and tradition and AI that need to be overcome. We need more guidance from the Supreme Court, for one thing. But I sense that the history and tradition method is consistent with, and indeed will thrive with, advances in AI. Those are my ideas today. I welcome your comments. Thank you for having me.
a good bit of time for questions, so I'll open the floor. How about Ben?
So I'm wondering, how do we get Justice Roberts to stop being flaky? It's not clear has no spine.
I don't know how that's a broad statement. First of all, I'd say that he's a fine Chief Justice, but are you referring to his end of the year report on AI, or what are you referring to?
No, I just generally find that he tends to side on the liberal opinions that don't have much of a basis of originalism, in my opinion, but maybe, I don't know.
Well, I think what I've found through looking at this issue is I don't think it's going to be driven by ideology. I think the technology is going to drive everyone in this direction, regardless of where you're coming at it ideologically. So it just seems to me the history and tradition method is assuming you can get answers by looking at a body of documents. And I don't think any other legal philosophy does it that way. And AI does it that way. So it just seems like that's naturally going to drive the way decision making is going to be done in looking at text.
Corey.
So I think we've seen that AI models can kind of be programmed to get the answer that you want to get. So isn't this just going to run into kind of the same problem we have with experts now, where one side is going to say, oh, here's an AI model that says it means this, and another side says, here's an AI model that says it means that. But if anything, it's a worse problem because with an expert, you can at least kind of do dabble and try to figure out if they're reliable or not. The AI model, the reliability is going to be hidden underneath a huge layer of complexity, and it's going to be at least expensive to figure out, if not impossible.
Yeah, I think the transparency is the really important part about the model. You have to, I think if you're going to rely on AI, you need to know what the sources are that are in the database that are being reviewed. And you're also going to need to know more about the model, the AI model that's being used. But I don't think that that's holding people back in other areas of scientific endeavor and whatnot that are using AI. So if it has enough reliability to be relied upon by scientists to do things, it seems like that could be worked out for the law as well.
So my understanding is generally a lot of this original history is opposed to purposivism as a method of statutory interpretation. But my question is, when you're looking at the history and tradition of something and applying it to a new life outcome, such as interpreting the Second Amendment in light of handguns, which did not exist at the time, is there a worry that you end up looking at what is the purpose of the history and tradition in order to analogize it to future unknown technology? And so my question is, does that history and tradition test lead into purposivism, or if not, how do you distinguish it from that kind of analogizing?
Yeah. When you are trying to determine levels of generality for analogies, I think you do have to import a notion of what the purpose was of a constitutional provision. I mean, I think there is that element to it. But as I understand the history and tradition, or originalism method is not to, there's still going to be parameters of what the ratification generation would have considered the purpose of a provision. But I see your point. There is going to be a purpose element to it. But I think that is going to be worked out through determining how close you need to be analogy-wise to whatever the founding era example is. And that's something we just don't have. I think the Rahimi case will probably give us more direction in that regard. But again, getting back to my topic, it seems like whatever those rules are that the court comes up with could be followed by AI to do analysis. You do have to work out those standards of how tight the fit needs to be, but I think it could be worked out and applied through use of AI.
Yeah, I have a question. What's your imaginary of the role of the judge? Because you combine these two topics. One is technology and one is judge. And this kind of imaginary is that maybe judge can do, maybe the AI can replace the judge in the future, especially grounding on your historical approach, because we can use machine learning to learn a lot of historical records, and it can produce a kind of machine learning of this kind of judges. But what if, before the Brown case, we use machine learning to make decisions, and we always use Betsy and those kind of records? And what would become in the future? Then the future would become there's no Brown case happening. So I'm curious about what is your imaginary of the role of the judge?
You're saying that if we had AI make the decision, we would not have gotten Bruin, you're saying?
Yeah.
Okay. It's possible. It's possible. I don't know. I guess I'd throw all this with a caveat. I don't think current AI usage is probably there yet to be able to do the kind of decision making that you're thinking of. But ultimately, I think it's going to come down to probabilities of meaning for words that are going to be able to, you're going to be able to get statistics from AI to tell you that. And ultimately, a judge is going to have to make a call as to, what is going to follow, what the judge is going to follow in determining the case. But you're going to have a more objective way of doing it, because you're going to be able to say this word or this phrase meant this the X majority amount of the time. So it gives you more of a basis for your decision than just to say, oh, we looked at a few sources, and this is what they said, which is kind of what we've done thus far with the way we look at history and tradition. And I think that's probably why the court went to balancing tests in the 20th century, because it was very difficult to do historical research in the 20th century in a comprehensive way. So I think it was easier to just do a balancing approach. But I think now technology will allow us to do more of the statistical method.
As a follow-up question. Yeah, so why is the time period? Because you mentioned different kind of timing, and
Yeah.
you mentioned nowadays we do not allow balancing anymore. Why is the time play a role here?
Why is today why are we abandoning balancing? Because I think there's an idea that the judge is assuming too much power in doing a balancing test.
John. Thank you. So I think when Justice Lee was here, he sort of suggested, or at least the way I understood it, was that we only would use corpus linguistics in sort of difficult cases where the sort of ordinary tools of interpretation don't give us a conclusive answer. As corpus linguistics and AI become more sophisticated and more reliable, do you foresee a time when we just sort of rely on corpus linguistics as like the first sort of entry point into interpretation, and like, we don't need to use dictionaries anymore or something like that?
Yeah.
And if so, if we get, find a case where corpus linguistics does not give us a sort of conclusive answer, but maybe even creates some uncertainty, then how would you resolve that case?
Well, first of all, I'll put this big caveat at the beginning, is that you obviously have to deal with stare decisis. And lower courts, we're not going to be able to do anything with history and tradition unless we've gotten a directive from the Supreme Court to do it, I think. And also, we have to be consistent with what the Supreme Court is binding on us, and also in our circuit. So you have to deal with that. But I was dealing with a caveat, but what was the question again?
So, do you foresee corpus linguistics sort of swallowing up
Swallowing.
other forms of interpretation?
Yeah.
And where it creates ambiguity?
I think AI could probably swallow up most of what we're doing for historical research if you have a comprehensive enough database to do it. And you would want to do it in a way that you could probably get your answer, you get your statistical answers, but you also can get examples from the research AI does, like you do now when you're using the BYU corpus linguistics. So you would still be able, the human could still be involved in checking what the AI is pulling up to see, how it lines up. And you can also, I think the human is still going to be able to, we're still going to have some creativity, I think, that we're going to bring to the process. But I do think, yeah, a lot of this research that we're spending a lot of time on now as humans will be supplanted by a machine doing a lot of it, because it's going to be more efficient.
Steve? This is kind of related to an earlier question, but I'm curious what you think the role of the judge versus sort of the adversarial system is here for AI, and whether you think that judges should be doing their own research to kind of come to these sorts of conclusions using tools about the historical meaning, or if you think it's a better system to defer to the parties and it's sort of their responsibility to bring in this evidence, and then the judge has to work with what's given.
I think you really should be having the advocates doing it in the first instance. The problem is the advocates haven't done it in a lot of cases. The first case I ever had en banc was this case called Turner, involving when the right to counsel attaches for a criminal defendant. And we had arguments. I had done some research. I got up there, the first question I asked, what do you think, why in the Crimes Act of 1790 the word accused and indicted were considered to have different meanings? And it goes to the meaning of the Sixth Amendment. The advocate had no clue what I was talking about. So and I was going to rule, I was inclined to say I thought the original meaning was that the right to counsel attaches earlier than the commencement of formal proceedings, based on what I had seen of the history. But like, this advocate didn't even do any history and tradition research for the case. It was probably, I think, his best argument. And so, like, it seems like to me the advocates, as they figure out they can make winning arguments using history and tradition, it ought to be in their interest to start making those arguments. If you you're going to have justices, certainly justices in the Supreme Court, but you're going to have more lower court judges who are willing to consider it too. And if the Supreme Court is saying we have to consider history and tradition, by golly, you better be doing it. So yeah, that's the best way, is that advocates do it. But I feel like I need to look at it also as a judge to make sure I'm being consistent with the Constitution, because ultimately my oath is to uphold the Constitution, and if I'm not doing that, I'm not doing my job.
Yeah, so you had mentioned, you quoted that judge earlier on in your talk on
Judge Reeves.
Judge Reeves, on the difficulty of using text history tradition, judges are amateur historians.
Right.
And I'm curious if you think that with the growth of AI and the decrease in resources that it would take to conduct historical research on what it would have meant at the time, do you think that text history and tradition as a judicial approach would start going into more terrains? Like you mentioned that text history and tradition is used in different forms of constitutional interpretation, but not in all. So do you think that that it would be expanded because of it doesn't take as much resources, or not? Why?
I think it will be expanded. I mean, ultimately, if you're being principled about it, it would be the whole Constitution.
It kind of falls over. Okay, cool. I'm thinking with First Amendment, freedom of speech, that what we have, it's built and changed a lot from what it would have been understood. Do you think in that context too that we would see?
I think that there is a lot of case law in that area, and the stare decisis principle will have a heavy weight in determining whether you go with history and tradition in that area. And I don't think that a majority of the Supreme Court would go with history and tradition on free speech. I don't think they have an appetite for that. But we'll see. I mean, we'll see what happens as technology develops, and see what happens with how that affects interpretation.
Tyler.
Yeah, a question going specifically to Kennedy, the case that you mentioned, and sort of how the history and tradition principle works there. One of the concerns that I have is that the post-incorporation of the First Amendment and the Establishment Clause following the 14th Amendment totally changes the meaning of what the Establishment Clause would mean, and especially how it's been used by courts since then. I'm sort of curious how you think about translating the founding era history of what an establishment would have been and how that would work to a contemporary context where all these intervening judicial doctrines have sort of messed up the maybe purist conception of history. That we
Yeah, I mean, that's not the only area. Fifth Amendment is another area that it happens. Yeah, I mean, you have to look at it from the perspective of, I mean, I'm thinking in terms of what is the 14th Amendment. I mean, an originalist purist would say it's privileges or immunities that you're looking at, but I think the court is probably not going to go that route. They're going to stick with due process as being the vehicle. I think you will look at, you're going to be looking at the history surrounding the 14th Amendment to make those calls on how the Establishment Clause of the Fifth Amendment or other Bill of Rights provisions are being applied against the states.
All right, how about we do well, and then we'll wrap it up with your future clerk, Parker.
Yeah, thank you. Sort of following up a little bit on Colin's question, I'm curious what you make of the majority's approach in Students for Fair Admissions, where it doesn't seem to be particularly originalist. Justice Thomas tries to do some originalism, but no other justices join him. But it's also sort of overturning precedent. Like, is there an opening to a critique that they're not being principled, that they're selectively applying text history and tradition methods, or what do you make of that case?
Yeah, I'm not gonna grade my bosses. I do think Justice Jackson probably made she delved into it, history and tradition, quite extensively in her arguments. All I would say about that case is that the fact that I think it was revelatory that history and tradition does not have an ideology, that it can be used to make arguments on both sides of the aisle, so to speak. The point of the process, though, is ultimately I think you try to come up with the best answer through history and tradition. That is not always a, quote, conservative answer. It's not always a progressive answer. I don't think that case really was, I don't think it was a pure history and tradition. But my point was, in invoking the case, is that the ideas of history and tradition are being used by all justices in different settings.
All you, Parker.
Okay, so I have a question about the use of tradition and practice. So there are professors at this law school who have argued, who have made arguments in favor of constitutional liquidation or historical gloss. You know, the idea that the way that people practiced the law around the time it was enacted can provide good evidence of what the law meant. The way I understand that, we use that when the text is ambiguous, and so practice can maybe provide meaning of what the text means. But if AI gets to a point where it can pretty definitively tell us what a text means, does that mean that practice should become less important? Arguments from practice should become less important? Does that mean that you would choose the AI definition of the text over potentially evidence of prior practice or tradition?
I think AI does both. It does the linguistics history, and it also can also do the practice. Because you don't know, it's amazing when you look back through history. I had a case involving the OSHA vaccine mandate, where I did a separate opinion about whether or not Congress had the power to pass this if they did it. And we found out all these interesting things about the way vaccines have been dealt with by Congress throughout history. So AI can do that kind of research also in a much more succinct way, efficient way than humans could do it. They could grab all those examples of anything that might potentially, we had situations where they, dealing with Indians, Native Americans, and vaccines. I mean, you can just find all sorts of things. AI I can imagine finding those things for those kinds of course of practice answers. And so what I would imagine is you're going to have the linguistics history of how the words were used, but you're also going to have the history of practice that could be maybe combined, or maybe they're just two different things that you're looking at that AI will assist you with, that you can look at to make a decision in a case.
We're out of time, but thank you very much.
Thank you.
Judge John Bush.